Hello everybody, and thank you for joining me today. Hope all is well from wherever you are. So let's go. So today's daf is Bava Kamma Daf 88 Omid 8. So continuing from the last daf. The Gemara objects, does it enter your mind that the father receives compensation for his daughter's wound, which unlike an injury does not diminish his daughter's value? Even Rabbi Elazar raises dilemma only with regard to an injury, by which he lowered her monetary value. There are those who hold that in any event, the payments for pain, medical costs, and humiliation are paid directly to the daughter, as written in the Rosh. Others hold that while the payments for pain and medical costs are paid to the daughter, the payment for humiliation goes to the father. They concede if the father has spent money to heal her, he recoups his expenses, and that's from the Baal Hamor and the Ramah. If one injures the minor daughter of another in a manner that lowers her monetary value, the payment for damage is given to her father. If the injury did not cause her monetary value to be lowered, the payment is given to her in accordance with the statement of Rabbi Yochanan. The money paid for loss of livelihood is given to the father. The Torah cited the Rambam writes that this is the halacha only if the daughter is supported by her father. But if she is financially independent, the payment for loss of livelihood is given to her. He also writes, citing the Rosh, that payment for loss of livelihood is given to her in any event. With regard to the payments for pain, medical costs, and humiliation, they are given to the daughter. If a man injures his own minor daughter, he must pay for her pain, medical costs, and humiliation. The Ramah writes that some hold that if she is supported by her father, he is entirely exempt. Rambam Sefer Nazich and Hilchot Hova Mazik 4:14 and the Magashir Mishnah there. Shulchan Aruch Mishpat 424:6. Diminishing the amount of money that her father would receive for her betrothal, but with regard to her wound, by which he did not lower her monetary value, Rabbi Elazar did not even raise a dilemma. Rabbi Yossi bar Chanina said, Rabbi Yochanan discussing a case where someone wounded her on her face, and he thereby lowered her monetary value, as it affects the amount of money that her father would receive for her betrothal. The Mishnah teaches one who injures a Canaanite slave belonging to others is liable for all the 5 types of indemnity. Rabbi Yehuda says Canaanite slaves do not have a humiliation, so one who injures a slave only pays only the other 4 types of indemnity. What is the reason, Rabbi Yehuda? The Gemara explains the verse states with regard to the indemnity of humiliation, when men strive together, a man and his brother, Deuteronomy 25:11, the formulation and his brother teaches that the payment of compensation for humiliation is applicable with regard to someone who had a relationship of brotherhood with a Jew. This is excluding a Canaanite slave who does not have a relationship of brotherhood. Eved she'ein lo chava. A Canaanite slave no longer has the status of a Gentile, but does not have the status of a Jew and shares no familiar ties with anyone. Therefore, it would be permitted for him to marry his natural mother, daughter, or sister. Ram Sefer Kedush Hilchot Yisrei Bia 14:17. Rashi explains this to mean that it's prohibited to marry a Jew. He also offers an alternative explanation that a Canaanite slave is not bound by familiar ties to those he was related to before becoming Jewish by virtue of being a slave, even if those relatives were to convert as well. Tosfot explain that he does not share common lineage with his children. And the sages who hold that a Canaanite slave is included in halakha of compensation for humiliation maintain that he is the Jew's brother with regard to observance of mitzvah, and the Canaanite slave is obligated to observe most mitzvah. The Gemara challenges, if that is so, then according to Rabbi Yehuda, who holds that slaves are not in the category of brothers, conspiring witnesses who testify that a Canaanite slave committed a sin punishable by capital punishment should not be put to death by the court. As it is written, you shall do unto him as he conspired to do unto his brother in Deuteronomy 19:19. And the slave is not considered a brother. Rav Sheshet said the same verse states with regard to conspiring witnesses, and you shall put away the evil from your midst, indicating that the punishment of conspiring witnesses should be applied in any case, including when they testified about the slave. The Gemara raises another challenge. If that is so, then according to the sages, you'll hold that slaves are in the category of brothers. A Canaanite slave should be fit for kingship, as it is written, one from among your brothers shall you set a king over you in Deuteronomy 17:15. The sages say in response, but according to your reading of halacha, disqualifying a common from being king should pose a difficulty for you according to all opinions, both according to the opinion of the sage and Rabbi Huda. Why is a convert not fit for a king, as he is certainly in the category of brother? The Gemara answers, rather the verse states, one from among your brothers shall you set a king over you, which indicates the king must be from the choices from among your brothers, which is qualified both converts and slaves. Let's see the note. As the Gemara will explain, this formulation indicates that a king must be selected from the foremost element of the Jewish people. A Jew born into a family of converts may not be appointed as king, even if his family had converted several generations ago. If his mother is not from a family of converts, he may be appointed as king. One say for Shoftim Hilchot Melachim Umil 1:4. The Gemara challenges further. If that is so, then according to the sages who hold that slaves are in the category of brothers, a Canaanite slave should be fit to bear witness, as is written, and behold, the witness is a false witness, and he has testified falsely against his brother. Deuteronomy 19:18. If a slave is considered a brother, why is he not eligible to testify in court? Well, I said you cannot say that a slave is fit to bear witness, because the halacha concerning a testimony of a slave is derived by an fortiori inference from the halacha concerning the testimony of a woman. And just as a woman who entered into the congregation, i.e. to marry a Jew of fit lineage, is nevertheless disqualified from bearing witness, according to the basic halacha, a woman is disqualified from bearing witness. Yet there is an ancient ordinance enabling women to testify with regard to matters about which men are likely to be able to testify, as well as in other cases where no other witnesses are available. I'm going to say for Shoftim Hilchot Eidot 9:1-2, 35:14, and the comment of the Ramah. So too, with regard to a slave who is not fit to enter the congregation, it is not because he is disqualified from bearing witness. The Gemara counters this derivation. What is notable about a woman? She is notable in that she is not fit to undergo the mitzvah of circumcision. Would you say from the fact that a woman is disqualified from bearing witness, one can derive the same is true for a slave who is fit to undergo circumcision? The Gemara explains the halacha of a minor shall prove that one's fitness to undergo circumcision is not germane to one's vocation to bear witness. As a minor is included in the mitzvah to undergo circumcision, and yet he is disqualified from bearing witness. And is qualified from bearing witness even if he is of sound intelligence. This is counted. What is notable about a minor? He is notable in that he is not obligated in the performance of mitzvot. Would you say that from the fact that a minor is qualified from bearing witness, one can derive that the same is true for a slave who is obligated to perform the mitzvot? The Gemara responds, the halacha of a woman shall prove the matter, as she is obligated to perform the mitzvot and is qualified from bearing witness. And the derivation has reverted to its starting point. An aspect of this case is not like the aspect of that case, and the aspect of that case is not the aspect of this case, as each case has its own unique halacha. The common denominator is that both a woman and a minor are not obligated to perform the full mitzvot and is qualified from bearing witness. I will also bring the case for the slave for inclusion for this in the halacha, as he is also not obligated in performance of all the mitzvot and is qualified from bearing witness. A woman is obligated, generally speaking, only in negative prohibitions and in positive mitzvah that are not time bound, while the only mitzvah applicable to a minor is that he must not undergo circumcision. Canaan says disqualified from bearing witness. Well, I'm going to say for Shoftim Hilchot Eidot 9:1-4, Shulchan Aruch Midbar 34:19. This derivation is rejected. What is notable about that common denominator? It is notable that a woman or a minor is not a man, and this is why they are disqualified from bearing witness. What do you say that from the fact that they are disqualified from bearing witness, one can derive that the same is true for a slave who is a man? The one offers a different derivation. Rather, derive the halacha that a slave is disqualified from bearing witness from that of a robber who is disqualified from bearing witness. A robber is disqualified from bearing witness until he repents. I'm going to say for Shoftim Hilchot Eidot 10:4, Shulchan Aruch Midbar 34:7. The Gemara objects, what is notable about a robber? He is notable in that his actions cause him to be disqualified. Would you say that from the fact that a robber is disqualified from bearing witness, one can derive that the same is true for a slave? The actions did not cause him to be unfit? The Gemara answers, rather derive the halacha from a robber and from one of these other two, either a woman or a minor. The common denominator is that they do not observe all the mitzvot and disqualify from bearing witness. So too a slave does not observe all the mitzvot and disqualified from bearing witness. Mara, son of Avina, said another derivation. The verse states, fathers shall not be put to death for children, Deuteronomy 24:16, meaning that people shall not be put to death based on the testimony of fathers who do not have common lineage, highest with their children. Highest lineage. This is derived through a metathesis from the word yahas, meaning familiar lineage. It is generally used to describe the most basic familial ties, e.g. the legal connection between a parent and child. With their children, this is referring to Canaanite slaves whose children are not considered to be related to them. For if it enters your mind to interpret the verse according to straightforward meaning, as we say, fathers shall be put to death for children, meaning by the testimony of their children, then let the merciful one write, fathers shall not be put to death for their children. What does the verse teach by stating only children without the word there? Learn from this formulation that people shall not be put to death based on the testimony of fathers who do not have common lineage with their children. The Gemara challenges this. If that is so, when the end of the verse states, nor shall children be put to death for their father, Deuteronomy 24:16, does this also mean that people should not be put to death based on the testimony of children who do not have common lineage with their fathers? But if that were the case, it would also be the case that a convert would be disqualified from bearing witness, as when a convert no longer shares common lineage with his parents. The sage is saying in response, how can these cases be compared? With regard to a convert, although he has no common lineage, converts are not bound by familiar ties. Even twin brothers who convert may bear witness with regard to each other. As the legal status of a convert who just converted is like that of a newborn child. From the moment one converts, he is considered a Jew with regard to all matters, and it is permitted for him to marry a Jewish woman. If he fathers a child with a Jewish woman, the child is a full-fledged Jew. From Sefer Kedusha, Yisrael Be'er 12:17, 15:9, Shulchan Aruch Even Ezer 49:4-9, Chodesh Mishpat 33:11. With those above him, i.e. his parents, he does have a common lineage with those below him, i.e. his children. This should exclude a slave who has no common lineage, either with those above him or those below him. The child of Canaanite slave should lineage with his mother, but not with his father. From Kedusha Yisrael Be'er 15:4. The sages prove that a convert is fit to bear witness. As if it enters your mind that a convert is disqualified from bearing witness, then let the merciful one write, fathers shall not be put to death for their children, according to the interpretation that we say. Fathers shall not be put to death based on the testimony of their children. And let the merciful one also write, nor shall children be put to death for their fathers, from which you learn two halachot. One, that children should not be put to death by testimony of their fathers, and another, that people should not be put to death by testimony of children who do not have common lineage with their fathers, i.e. converts. The Gemara continues the statement, and the halacha with regard to a slave being disqualified from bearing witness is derived by an a fortiori inference from the halacha of a convert. And just as with regard to a convert, that it is the case concerning those above him that he has no common lineage, but with those below him he does have common lineage, and he is disqualified from bearing witness. Then with regard to a slave who has no common lineage with those above him or those below him, all the more so it's not logical that he is disqualified from bearing witness. The Gemara continues the statement. Rather, due to the fact that the Merciful One did not write the verse that way, but instead wrote, fathers shall be put to death for children, which indicates that people shall not be put to death based on the testimony of fathers who do not have common lineage with their children. And then from this formulation that with regard to a slave who has no common lineage with those above him or those below him, he is the one who is disqualified from bearing witness. With regard to a convert, since he has common lineage with those below him, he is fit to bear witness. And if you would say that the Muslim write, neither shall children be put to death for their fathers, why do I need that which the Muslim wrote, nor shall children be put to death for their fathers, which indicates that people shall not be put to death based on the testimony of children who do not have common lineage with their fathers? The Gemara answers, since the Merciful One wrote, fathers shall not be put to death for children, he also wrote in the same manner, nor shall children be put to death for fathers. The Mishnah 87a teaches with regard to a deaf mute, an imbecile or a minor, an encounter with them is disadvantageous, since one who injures them is liable. but if they were the ones injured, they are exempt. The Gemara relates an incident. The mother of Rav Shmuel bar Abba from the city of Hagoronia was married to Rabbi Abba. She signed over her property. Signed over her property to Rav Shmuel bar Abba, her son, after she died. We'll just explain the funa. This is at the end of the Omid. We'll continue in the next time. She wrote her property. In attempting to explain why Rav Shmuel bar Abba's mother saw fit to designate her property for Rav Shmuel, some explain that his mother had been previously married to another man named Abba, who was the father of Rav Shmuel. She then married a man named Rabbi Abba. Therefore, she designated the property to her son Rav Shmuel, so that it would not end up in the possession of her second husband. Others explain that Rav Shmuel was in fact the son of Rabbi Abba, but his mother designated the property for him so that the children of Rabbi Abba from another marriage would not inherit the property. Thank you for listening and wish you all the best. Bye.